All right, thanks, guys, for being here on time. I know Delegate Adams is coming. Delegate Rose is going to be absent today. We have about 9 bills on the docket, voting list number 15 for today, Monday, March 30. We will start off with House Bill 797.
Thank you, Madam Chair. House Bill 797, Employment Discrimination, Fire and Rescue, Public Safety Employees, Use of Medical Cannabis. This bill addresses employment discrimination protections for fire and rescue public safety employees who are registered medical cannabis patients.
Thank you. Move favorable. Second. There's been a motion and a second on House Bill 797. Is there any discussion? Seeing none. Vice Chair?
Yes.
Delegate Turner? Yes. Delegate Fennell?
Yes.
Delegate Pruski?
Aye.
Delegate Howard?
No.
Delegate Johnson?
Aye.
Delegate Boffo is excused. Delegate Bandari?
Yes.
Delegate Rogers?
Yes.
Delegate Chi?
Yes.
Delegate Aaron's?
Vote this time.
Delegate Queen is absent. Excused, I'm sorry, excused. Delegate Ampry?
Yes.
Delegate Adams? 797.
Respectfully.
Respectfully.
Delegate Pippi?
Yes.
Delegate Crosby is excused. Delegate Rose is excused. Delegate Wyville?
Waiting for the computer to come on, I'll maybe.
Okay. I'll wait for your computer to come on. It's House Bill 797, the Employment Discrimination, Fire and Rescue, Public Safety Employees' Use of Medical Cannabis. No? Just so you know, Delegate Pippi said yes, just to make sure you heard what was going.
He did it.
Okay, just making sure.
And he's the minority leader.
He's the minority whip. Okay, no, Wyville? Oh, okay, no.
I'm trying to speak it into existence.
Delegate Roberts? House Bill 797 passes 11. Senate Bill 32.
Senate Bill 32 extends the time frame from 30 to 90 days that blood work results required to participate in Maryland State Athletic Commission events may be considered valid. There are no amendments.
There's been a motion favorable and a second on Senate Bill 32. Any discussion? Seeing none, Vice Chair?
Yes.
Delegate Turner?
Yes.
Delegate Fennell?
Yes.
Delegate Pruski? Delegate Howard?
Yes.
Delegate Johnson? Delegate Boffo is excused. Delegate Bandari?
Yes.
Delegate Rogers?
Yes.
Delegate Chi?
Yes.
Delegate Aaron's?
Yes.
Delegate Queen?
Yes.
Delegate Ampry?
Yes.
Delegate Adams?
Yes.
Delegate Pippi?
Yes.
Delegate Crosby is excused. Delegate Rose is excused. Delegate Wyville?
Yes.
Oh, Delegate Roberts. Senate Bill 32 passes 16. Senate Bill 43
Is the cross-file of HB 259, which we heard in this committee. It sets up an investment venture fund, and it passed, the Senate bill, I think both passed out of the House and the Senate unanimously.
There's been a motion of favorable and a second on Senate Bill 43. Any discussion? Seeing none, Vice Chair?
Yes.
Delegate Turner?
Yes.
Delegate Fennell?
Yes.
Delegate Pruski? Delegate Howard?
Yes.
Delegate Johnson? Delegate Boffo is excused. Delegate Bandari?
Yes.
Delegate Rogers?
Yes.
Delegate Chi?
Yes.
Delegate Aaron's?
Yes.
Delegate Queen?
Yes.
Delegate Ampry?
Yes.
Delegate Adams?
Yes.
Delegate Pippi?
Yep.
Delegate Crosby is excused. Delegate Rose is excused. Delegate Wyville?
Yes.
Delegate Roberts? Senate Bill 43 passes 16. Senate Bill 133.
Thank you, Madam Chair. Senate Bill 133 extends the termination date for 5 occupational and professional licensing boards and commissions within the department through 1 July 2032. There are no amendments.
Delegate Pippy.
One we all voted unanimously before, right?
Yep.
Okay.
There's been a motion for favorable and a second on Senate Bill 133. Any further discussion? Seeing none. Vice Chair?
Yes.
Delegate Turner? Yes. Delegate Fennell? Delegate Pruski? Aye. Delegate Howard? Yes. Delegate Johnson? Delegate Boifo is excused. Delegate Bandari?
Yes.
Delegate Rogers?
Yes.
Delegate Chi? Yes. Delegate Aaron's? Aye. Delegate Queen? Yes. Delegate Ampry? Yes. Delegate Adams? Yes. Delegate Pippy? Yes. Delegate Crosby is excused. Delegate Rose is excused. Delegate Wyval? Yes. Delegate Roberts? Yes. Senate Bill 133 passes 16. Senate Bill 197.
This Senate bill conformed to the House version is passed by the House. Senate Bill 197 is a departmental bill that modifies the elements that a local jurisdiction must include in a comprehensive plan to be consistent with the existing planning principle and applies the element consistently across all jurisdiction and updates plan requirements.
There's been a motion for favorable and a second on Senate Bill 197. Any discussion? Seeing none. Vice Chair?
Yes.
Delegate Turner? Yes. Delegate Fennell? Yes. Delegate Pruski? Aye. Delegate Howard? Yes. Delegate Johnson? Aye. Delegate Boifo is excused. Delegate Bandari?
Yes.
Delegate Rogers?
Yes.
Delegate Chi?
Yes.
Delegate Aaron's?
No.
Delegate Queen? Yes. Delegate Ampry?
Yes.
Delegate Adams?
No.
Delegate Pippy? No. Delegate Crosby is excused. Delegate Rose is excused. Delegate Wyval? No. Delegate Roberts? Yes. Senate Bill 197 passes 12. Senate Bill 216.
Thank you, Madam Chair. Senate Bill 216 is the same bill that we passed out of committee and out of the House. It's HB 242. It's confidentiality of unemployment insurance information, and it aligns the state with the federal guidelines. It passed the Senate Finance 10-0 and the Senate floor 44-0.
There's been a motion for favorable and a second on Senate Bill 216. Any discussion? Seeing none. Vice Chair?
Yes.
Delegate Turner? Yes. Delegate Fennell? Yes. Delegate Pruski? Aye. Delegate Howard? Yes. Delegate Johnson? Aye. Delegate Boifo is excused. Delegate Bandari?
Yes.
Delegate Rogers?
Yes.
Delegate Chi? Yes. Delegate Aaron's? Yes. Delegate Queen? Yes. Delegate Ampry?
Yes, as long as that cricket ain't real.
Delegate Adams? Delegate Adams? Delegate Pippy?
Yes.
Delegate Crosby is excused. Delegate Rose is excused. Delegate Wyval? I have to call him Jiminy Cricket now. Delegate Roberts? Senate Bill 216 passes 16. Senate Bill 226.
Thank you, Madam Chair. Senate Bill 226, conform to the House version, is passed by the House. This bill modifies the composition of Maryland Heritage Areas Authority, alters the requirements for state officials' support of heritage areas, and alters provisions related to authority grant and loan awards.
Delegate Pippy.
Was this the bill that we offered that amendment in subcommittee to remove that language, and then it was like rejected? Is it the same one? Okay. All right. Thank you.
Yes, Delegate. PP.
Okay.
Any further discussion? Is there a motion?
I'll move to favorable.
Okay. Senate Bill has been moved. Senate Bill 226 was properly motion favorable, and a second. No further discussion. Vice Chair?
Yes.
Delegate Turner?
Yes.
Delegate Fennell? Yes. Delegate Pruski? Delegate Howard? No. Delegate Johnson? Delegate Boffos excused. Delegate Bandari?
Yes.
Delegate Rogers?
Yes.
Delegate Chi? Yes. Delegate Aaron's? No. Delegate Queen?
Yes.
Delegate Amprey?
Yes.
Delegate Adams? No. Delegate Pippy? No. Delegate Crosby's excused. Delegate Rose is excused. Delegate Weigel? No. Delegate Roberts? Yes. Senate Bill 226 passes. 11. Senate Bill 784.
I believe is clarifying information about who should be licensed for specific consumer loans. This is wording, I think, that came from OFRs. It passes unanimously and didn't have any issues. So move favorable, I would assume.
Senate Bill 784 has been properly motioned favorable and second. Any discussion? Seeing none. Vice Chair?
Yes.
Delegate Turner? Yes. Delegate Fennell? Yes. Delegate Pruski? Aye. Delegate Howard? Yes. Delegate Johnson? Aye. Delegate Boffos excused. Delegate Bandari?
Yes.
Delegate Rogers?
Yes.
Delegate Chi?
Yes.
Delegate Aaron's?
Yes.
Delegate Queen?
Yes.
Delegate Amprey?
Yes.
Delegate Adams?
Yes.
Delegate Pippy?
Yes.
Delegate Crosby's excused. Delegate Rose is excused. Delegate Weigel?
Yes.
Delegate Roberts?
Yes.
Senate Bill 784 passes 16. House Bill 774.
Is a bill, it's enabling legislation. It allows local counties to establish, if they choose, a good cause eviction law, which sets down very specific reasons that a landlord can terminate a lease at the end of the lease provision. And then it also establishes the reasons that a landlord can not extend the lease based on whether they're doing construction, passing the property on to a family member. And if a county chooses to implement the law, it has to implement it for property owners with at least more than six units. I'm going to move favorable.
House Bill 774 has been properly motioned favorable, and a second. Any discussion? Delegate Adams and then Delegate Aaron's.
Okay, so did we ever, council, did we ever get to the point where we were able to define what a substantial breach would mean in a court?
I don't think I remember talking about substantial breach or substantial on maybe another bill, but I don't recall us talking about substantial as it relates for this bill.
So a substantial breach is an interpretation, I would assume, and the reason why I ask is that in the bill, there is a requirement that the landlord approve by the preponderance of the evidence. I'm not an attorney, but I believe that's the 50-50 rule where you have to prove in a court of law beyond the 50% that there was a breach of lease. And so in two situations, I'm saying that that's a high burden, and then that burden is being met by how do you prove substantial in the court. It's not good enough to say, here are the list of, and the reason why I'm asking, because I'm going to have another question for counsel. It's not good enough to simply say, okay, we're going to give you the standard in a court of law, and we're going to say substantial. We're now going to talk about, okay, issues like you can have somebody removed under the eviction bill should it pass for illegal activity. So and my question is, how do you prove by the preponderance of the evidence that there is an illegal activity that is substantial?
So
I assume stealing gum from the corner market's not substantial, but maybe a gun violation is. But where do you draw that line under the bill?
Yeah, I'm seeing in the bill, there is that separate ground for a tenant engaging in illegal activity on the premises as a separate ground, separate and apart from the substantial breach of the lease, if that's helpful for like illegal activity.
So how about, so how about disorderly conduct? What is disorderly conduct? Okay, you're going to say it disturbs the peace and quiet of other tenants. But again, I go back to, under the bill, a tenant has to have committed a substantial breach. So it's not just simply a tenant's engaging in disorderly conduct. It has to be a substantial breach, which is back to the point I'm making about how do you, in a court, in a preponderance of the evidence, prove that the tenant was engaging in disorderly conduct that disturbs the peace and quiet of other tenants in a substantial way.
Right. I think, and yeah, to try to answer that as best I can, I think we have, because those are separate grounds, they're going to have separate standards, and there's, that is separate and apart from the substantial language for the breach of the lease. And then the last thing I would just add is there's also that ground Roman numeral 6 for minor violations. So there's a number of different, I guess, grounds for good cause for the landlord to, have available for that.
But even if you have minor violations, they have to be a substantial breach. And you still have to go to court, theoretically, if it's challenged in a minor violation by preponderance of the evidence that there was that minor violation. So I'm saying the same thing 3 different places in this bill where we're asking, what does substantial mean? How does this burden in a court of law play out where a landlord who is not law enforcement is having to conclude whether somebody is conducting illegal activity? And then in a court of law, you're asking a landlord to determine what's a minor or not a minor violation. Let me ask another, if you don't mind, Madam Chair. A tenant habitually failing to pay rent when due. How do we define habitually?
Yeah, I think there is some more guidance in the rest of that provision. More than 10 days late at least 4 times in a 12-month period. So that's kind of like your more like prescribed explanation for what habitually would mean.
So the tenant pays the rent on the first of the month. It's due on the first of the month. And in essence, a 10-day notice can be sent on day 2, so they're late on the second day. And you're saying then if a tenant is 10 days late, less than 10 days late, but 12 months out of the year, that they would not be habitually late under the bill?
Yeah, if it's less than 10 days late, it wouldn't be meeting that a ground for cause.
Okay. I'll move to another section. On page 7 of the bill, a landlord in good faith seeking to remove the leased premises for at least 1 year from the rental market. Explain to me how in a court where that gets challenged, how a landlord's going to prove that that decision was being made in good faith.
One example that's coming to mind is maybe like what would not be good faith would be the landlord saying that they're going to remove it, but then maybe it's later determined or revealed that this was just being done as a way to get around the good cause requirement.
So you sense my concern with that, because a tenant or landlord could in theory say in good faith that they're going to be taking the property off the market, and then 9 months later they change their mind. How does that look in a court of law? Does the tenant who got removed then have a claim to make that the landlord was not acting in good faith, and what would be the relief that the tenant would avail themselves in that scenario?
Yeah, it would depend on the facts for that one, but I think at least 1 year, for what it's worth, that's like a rather significant amount of time as opposed to a period shorter than that. So.
I mean, Madam Chair, the problems I have with this bill, I could do this for the next 20 or 30 minutes because I live this business. And the problem with the bill is that we're calling it a good cause eviction bill. That's not what this is. This is the state of Maryland saying there will no longer be non-renewal of leases. So if we're going to say that a landlord can no longer have a 12-month lease that begins on the 1st of April, tomorrow, and ends on the 30th or 31st day of April, whichever day that is, because we're passing a law that means you can't have a one-year lease, then what is the bill doing? Because what the bill is doing is it's ending one of the key components of a contractual relationship, which is a start time by terms of the lease and the end time by term of the lease. And so I'm of the opinion that if the committee is going to pass a bill like this, I believe we just moved and seconded it without any amendment. And I didn't even try, to be honest with you, to get into the bill in a practical sense. I just brought some things that I think would happen in a court of law on a regular basis. It's not to challenge counsel. It was merely to say, here are the things, and out of respect, I don't know how on a bill drafted like this, counsel could answer it any differently than the way it was answered, which is we think, we interpret, we read, but I think we all know in a court of law, substantial has to have a meaning. I think that the legislature, if the bill is going to pass like this, there has to be understanding, there has to be clear paths to compliance with it, which I've said many times. It's something that I brought up. This bill has hit the House floor. It came out of different committees, so I'm one of the few members on the House floor that know the subject and have said these same sort of things. And I have severe concerns with the bill that we're passing it without any amendment. But if we're going to
hold the bill for an amendment.
Oh, okay. Can I hold the bill for an amendment? Amendments? Okay. Well, then my feeling on this is that this bill is not ready for even close to being made law, and I'm going to vote no on it. And out of respect for the committee and their time, I'll stop the things that I would talk about because there's too many.
Thank you, Delegate Adams. We'll go with Delegate Aaron's and then the Vice Chair, and then Delegate Queen.
Okay, thank you, Madam Chair. Back on what Delegate Adams was saying on page 7, a landlord having obtained permits and blah, 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 and it says, in good faith seeking to remove the leased premises for at least 1 year from the rental market. Can you tell me what that exactly means? If I start working, or is this on me to remove it, or if I have repairs that will keep it?
Thank you. So at least 1 year from the rental market, that could be something where the landlord's had a change in circumstances, and perhaps now they are going to be using it for themselves, for family members, or they're going to be putting it on the market to sell it. Those are just a couple of ideas, I guess, for that ground.
It kind of read differently to me. It kind of reads to me that I have to take it off for at least 1 year if I do decide to do something. Is that right?
So, no, that's not my understanding. I think the landlord is going to be removing it for at least 1 year from the market as a rental property, so.
Okay. What if I'm going to take it off the market? What if I had major problems like my septic, and when the septic overflowed, it put some, I don't know, mold and mildew and all that stuff. It was going to take me 5 months. What does the landlord do then?
So there is a separate ground that it would speak to that maybe a little bit better, which would be also on page 7, but Roman numeral 9, where the landlord's doing, significant renovation that can't be completed while the premises are occupied. That could be another ground for the termination of the tenancy.
Okay. Back out, now I'm going to go to another one. I'm not sure I understood all that, but I'll go to page 6. Like down around line 31, I think Delegate Adams was asking about if more than 10 days late for at least 4 times in a 12-month period. It used to be, I used to be able to say as soon as you were late, I could start actions on you to get rid of you. This is telling me now you could be late 4 times in a year, 10 days or more. I'm late on the rent. I'm filling that bill, and after that, I may be able to get rid of you. Is that right?
That's right. Yeah, I think there's a little bit more.
I find that hard to take because, you know what, these are people with homes that might be, they need 6 homes, and I understand it's enabling, but that's kind of really generous with somebody else's money, in my opinion. The other thing I was looking at was on page 3, line 3. It's asking us now to disclose the members of an LLC. Is that correct?
That's generally correct, yes.
You know what, I'd like the delegate, I just find so much of this thing, finding more ways to harm landlords, and I'm not sure how much, does anybody have statistics on how often this occurs where we just get rid of people for no reason? Is there any statistics on that? Do you know by any chance? Does anybody know? You do? Okay. If you don't mind.
So I'm going to call on the vice, after that, do you have more questions, Delegate Ahrens?
Well, I might if she.
Okay, all right, okay.
So, sorry, your question is how often are people's leases ended without a reason given? Is that what you're saying?
Yeah, how often do we run into a circumstance where somebody is being let out of removed from a lease without any cause?
That they would prefer to, yeah, it's my understanding that it's 4,000 to 5,000 a year in the state. Now, some of those might be the active, retaliation that we're most concerned about, or that's not the only thing we're concerned about, the active retaliation that we're partially what we're concerned about. But for all of those folks, their lease is ending, and this is, their lease is ending, and, in terms of the stability of the, I answer your question, I'll say other things when it's my turn, so.
You answered, I'm not sure, I'd like to see that, because I understand what you're saying, and there may be instances, but typically when somebody's leasing, especially with 6 units, they're trying to keep those units filled at all times. And I don't understand that we're putting a bill in pretty much saying you can't do that, and you have to literally use your capital for months and months at a time to keep people in a place where you don't want to get rid of them. You'd just like to get a good tenant. And when you read through the bill, the stipulations are crazy. I mean, it's just up and down the line. We're hitting people with, here's what you can't do. And I think we're just opening it up to where landlords are going to react to this stuff. And I don't know how they're going to react to it, but they have to be able to cover their expenses and their costs to keep their business profitable. I don't see the bill as workable, in my opinion. Isn't that so? I'm done then.
Okay. We'll continue with Vice Chair Delegate Queen and then Delegate Weigel.
Madam Chair.
Oh, wait, sorry, I think it was.
Oh, you still talking?
Well, she was answering his question.
That's right. Thanks. No worries. Thank you. Thank you, Madam Chair. I'm going to try to answer the questions. I think I want to start with sort of 3 really important points. First of all, this is enabling legislation. So Delegate Adams, to your point about we'll pass this bill and landlords across the state all of a sudden, whatever, anything that you want to fill that blank in with is just not accurate. Because after this bill passes, each of the local jurisdictions still has to go through their own deliberations. And so while this bill restricts what the actual just causes can be, there's a bunch of other things that local jurisdictions can add about what they want in terms of how it's enforced, how it's educated, how they educate landlords, all of those kinds of things. That's the first thing. The second thing that I want to highlight is that this distinction, again, Delegate Adams, to your point, this is a list beginning on page 6, going on to page 7, of what are considered to be good causes that allows a landlord to end the lease from a tenant holding over. The first one is the substantial breach of lease, about which there's a lot of case law. But none of the others are tied to substantial breach of lease. So any of these other things can be in place, even if there's not a substantial breach of lease. And all of these other things on this list can be a reason to end the lease. The third thing that I wanted to highlight is that on the tenant's failure to pay rent, while this is specifically listed as a good cause to end the lease from renewal, it doesn't in any way restrict, Delegate Ahrens, I think you were concerned that this somehow restricts your current ability to file an action on non-payment of rent. This doesn't restrict that. So landlord can still file non-payment of rent action separate from this and pursue all of the rights that they have in court currently under law. This is just if the tenant is still in the unit at the end of their lease, if one of those other sort of pathways hasn't removed them from their unit, but there has been more than 4 times 10 days late, then that becomes a just cause to end the lease. But it doesn't change any of the other rights that a landlord has to pursue those things. I also wanted to highlight this distinction. I think there was confusion about if the permits to undertake substantial repairs had to be for 1 year, and they don't. You see, those are 2 separate things, and they're separate things on a list, and the reason it's tied to by an and is because at the top of page 6, it says these are the grounds that a local law can include. And so the and doesn't mean you have to have all of them. It means these are the laws that can be given, but it's actually an or. So you could have to make substantial repairs to the septic system that's going to take 4 months, and that would be a reasonable reason to end the lease. That's different from you're taking it off the market for 1 year. So I just think that's a really important distinction. And I think that was the questions. I'm trying to remember if there was another question that was asked that I haven't gotten to. If there is, text it to me and I'll ask it. I'll try to answer it. So that's on the technical side of things. I think on the specific side of things, in addition to the fact that it's enabling, so each local jurisdiction would have its own kind of version of this, I would just say that for those jurisdictions that are considering it, and that is Montgomery County is considering it, one of the reasons that we're considering it is certainly the retaliation question, the tenants who organize and are afraid to speak up. These are generally in multifamily buildings where tenants, with absentee landlords, where tenants are afraid to speak up and because their lease could just end. But the other is because of the impact on schools. And this is a really important part of this is that, in the communities with a lot of high-rise apartments, with a lot of turnover tenants, the school systems are affected by students who are constantly turning over. And so one of the folks you'll see in support of these kinds of bills are educators and people who work with kids who are otherwise harmed by the constant turnover of their leases and the stability and the benefits of children not moving constantly from school to school are one of the reasons to sort of support these kinds of bills. Thank you, Madam Chair.
We'll go to Delegate Queen, then Wyville, then Pippy, and then Adams.
Thank you, Madam Chair. So I guess my question is, because I know Montgomery County is probably one of the counties, and this is enabling legislation, but we did get an unfavorable, and I didn't take any notes, so if anybody can give me some insights, from our greater Bethesda chamber, one of our larger chambers that was unfavorable. Do we have any insights into what their concerns are? I mean, but was anything we could do to address their concerns? Because again,
Go ahead,
it looks
counsel.
like anybody knows exactly what they are trying to get to. Yeah.
My understanding of the Greater Bethesda Chamber of Commerce, I think that's what it was. I think it seemed to me like it was more of just a generalized objection to the policy of the bill. But if there was like a specific part within that, we could definitely talk more too.
Thank you, Madam Chair. So I get it, this is enabling legislation. So question for the council. So you could end up with every county overrides municipal, right? Is that what I read in this bill? So if a county adopts this good cause, it applies to the municipality within that county with the exception of Baltimore City, I assume.
With the exception of Baltimore.
Was that yes?
That's right.
Okay. So Delegate Adams raised a lot of questions about definitions. So is each jurisdiction and have the ability to define that definition in the manner in which they see fit? So you're not going to have uniformity throughout the state, but you're going to have, potentially 24 different interpretations of this bill?
That's a Good question, but I think that, that regarding that term substantial, of course, it's going to depend on specific facts of the case, but this is still going to be a state law that counties are adopting. So in terms of like uniformity, I think there's still going to be a lot of uniformity because it's going to be within this good cause, platform or.
But local good cause quoted in the bill, that's not defined in this statute or in this law, is it? So you could have each county or jurisdiction deciding what local good cause is.
And is there, I'm just asking, is there a certain part in the bill where that's said or?
Yeah, I had it here a minute ago, but I switched from it. It talked about local good cause.
Yeah, I think when they're, if I may, I think when they're saying local good cause, it's referring to the good cause adopted by the county, but it's still guided by the state law.
But they could have their own definition of it, right?
I don't think there's much opportunity for a definition within that because it's guided by the law that is before the committee now.
So you'd have uniformity within each county, but not within the state. So the intent of this legislation is not to create uniformity statewide?
Yeah, I think it's going to be, right, counties that don't adopt the good cause law as it's laid out in the bill won't have good cause. And I think that's just part of like a compromise.
And those that do will have their own interpretations of definitions.
I guess that's possible, but I don't necessarily think that that's likely just because the good cause law that's being adopted by a local jurisdiction is still going to be guided by the template or by this state law that is giving these jurisdictions the power to adopt it.
So it's on, what page is this? Page 5, it talks about line 23 through 25. The landlord shall be subject to the local good cause requirements of the county for that action.
I think that is regarding the complaint that they're filing.
But what are the local good cause requirements? Are they defined by that county?
The good cause grounds are going to be the grounds that are specified in this bill, and those have to be adopted by the county that's adopting good cause.
So if the county adopts a definition that the state doesn't potentially agree with, they're subject to lawsuit by the state, by the AG? Who enforces those definitions?
Well, if a county is adopting a good cause grounds that are different from this, I don't think a court would enforce those grounds, whether that's like in a landlord-tenant dispute or.
But what if it's not, what if the grounds aren't raised by the landlord? Washington County may adopt a totally different definition than Montgomery County, which I suspect they would. So is the state going to sue Washington County if it doesn't necessarily like its interpretation of a certain segment of this law?
So I don't think that would be necessary, perhaps, just because if it's not complying with the state law, then wherever this lawsuit or wherever, if a party's trying to enforce under a local law that doesn't comply with the good cause law, then it wouldn't be enforceable because it's not in conformity with the state good cause law that the county was supposed to have adopted.
Not sure I totally follow that, but I'll let it go. Thanks.
Just trying to figure out this scenario here. The 10 days late for 4 months within a year. So is it fair to say that if a tenant is late, let's say 3 times in a year. And on those 3 times, the landlord brought a court action that went to court. You know, you paid an attorney, you get to court, and, you know, the tenant then paid, you know, at some point. And so that was like dismissed. In other words, it wasn't like a judgment of possession wasn't ordered. But this has happened like 3 times, you know, so the landlord's like, I've had to take you to court 3 times. And now it's the end of the year and the lease is up. Would the landlord in that scenario not be allowed to end the lease? It's like the landlord's been to court 3 times for 3 29-day late rents. So is there no way that the landlord couldn't use those 3 court appearances to end the lease?
I think the failure to, like, if they're not using the failure to pay rent relief that would be available to them, then this ground, if it wouldn't rise to the level of being habitual for this ground, so no.
Do you think that the court would probably use this law to interpret what is this now defining what a habitual late payer is now in Maryland?
You know, it's possible, but I think it's pretty confined as a good cause ground within this legislation. So it seems like it wouldn't necessarily be interfering with the failure to pay rent action that a landlord could still bring.
And the only reason I bring this up is, and I hate to inject anything I do outside of here, but it's pretty common, I think, in district court that if somebody's late, but then they eventually make a payment and the lease is still ongoing, that you don't end the lease. And so the only remedy that these landlords actually have is when the lease ends, because, you know, whether the tenant's late or not, usually they're late multiple months in a row. But I feel like in this scenario, if they're late 3 times, you've been to court 3 times, or they could be late under this bill 12 times in a row, as long as it's less than 10 days. So they could be late 12 times in a row, in theory, under this bill, as long as it's less than 10 days, or they could be late 3 times for 29 days each. The landlord pays somebody to go to court, maybe me, maybe. And the landlord still wouldn't be able to end the lease, even though the landlord's paid an attorney 3 times to go to court. Is that, I mean, I think you answered it, but that's certainly a reasonable likelihood of this bill, don't you think?
You know, of course, that sounds like a valid experience maybe that you've had. I just, but I'm not sure how that may be.
Well, I don't own any apartments, but I've definitely been to court a few times. But you answered it, counsel. Thank you. Okay. Yep.
We have Delegate Adams, then Howard, then Vice Chair.
Thank you, Chair. And Delegate Pippy, let me just say, what I think's happening in that part of the law is a sloppy way around the no right of redemption, because a no right of redemption is having to go to court and get a judgment 4 times in a 12-month period. So they don't want to actually come out and say in the bill, for whatever reason, I don't get it, but they don't want to come out and say, if you've gotten what is current law, the no right of redemption, then this violates law. They're taking something that is fairly well understood and they're muddying it under the bill. They're creating a lower standard for the purpose of confusing. And Chair, let me just say, look, for 12 years, Bob Smith, Laura Addis, I mean, we ask questions of council, others, Tatiana, Ebony. Look, we ask questions of council because we are trying to get independent, nonpartisan answers to questions. It's not to put my friend on the spot. It's to simply say, we've got some problems with the bill and we'd like to have answers. I honestly think that this back and forth is legitimate in the sense that it's hard in a legal sense to answer these questions. And unlike Delegate Pippy, who doesn't have real estate, I have real estate. I've sat in a court and I've watched a judge look at me and say, sir, you are right on the basis, but I'm not going to let you evict this tenant. and then walk away and give a judgment to the tenant. I've seen that happen because I've lived it. And so I think that a district court judge is going to side with the tenant as often as they can, with as many tools available at their arsenal, when they believe that the landlord's being a little bit heavy-handed. All I'm saying is that there's a lease, and a lease is a binding contract between two parties. And we can and should expect the courts to interpret that lease strictly, and also, I believe, Chair, through the lens of a lease by way of contract has a term. In fact, the first sentence in a lease is, the term of this lease shall be 1 year, 2 year, month to month, week to week, I don't know. But the point is that you start with a term, a thing that begins, a thing that ends, and that this bill removes the thing that ends a lease. It goes to the fundamental aspect of contract law, and it does it in a way that, frankly, if you look at it through the lens of me I'm not trying to be difficult with counsel. I'm trying to simply say I've lived it. I've watched what happens in court. I know what my attorney says when I try to do a breach of lease action. Okay, so everything that'll have to happen if this bill passes from here forward is not going to look like a non-renewal of a lease with a tenant holding over. It is, you've got to go to court and prove a substantial breach of lease in a court of law with a tenant that will likely go into that same court and say, Mr. Landlord, you're wrong. That's not what happened. And so the judge is going to say, well, Mr. Landlord, prove to me that it happened. And I'm simply saying to you, counsel, chair, members who have the policy chops, but I've lived in a court and understand how this plays out, that this bill essentially removes non-renewal of leases as a tool available for a landlord when needed, because if a tenant's paying the rent, if a tenant's being a good tenant, they're staying. They're not going anywhere. And so this bill is unworkable. There are definitions that are not answered through this back and forth. I will disagree on at least a couple of points that the vice chair made, but the most important one is, if we're saying it's local bill, then we're saying that Wycomico County is going to potentially enact good cause eviction, but the neighboring county, Dorchester, doesn't. How is a landlord supposed to work in that lens, where one rule accounts for one county and the other doesn't for the next county? How does that work? Maybe the only way to get a bill like this passed is to make it say, okay, we're going to make it enabling, make it seem like it's innocent, like it's not difficult. No. This is one of the most difficult bills on housing that we will face this year in Annapolis. And so saying to me that this bill is no big deal because it's enabling, it was wrong. We have every county in the state, some that could take advantage of this, some that don't. And I'm saying, as a landlord that has multi-jurisdictional holdings, that having different rules between which county you operate in is not fair or equitable to the landlord who's trying to run a business. It's not easy enough to say that we're looking at it through the lens of substantial breach of lease, and we're going to give you those examples. Because I've already said it's defined in the bill poorly, and that in a court of competent jurisdiction, simply saying that somebody's doing something illegally is not good enough to sit as a landlord in front of a judge and say this tenant is doing something illegally, because you have to prove it by preponderance of the evidence. And what role does a landlord have in proving whether somebody's doing something illegally on the property? Back to my point, and I'll close. There's a reason why a lease has a beginning and a lease has an end. Maybe the two parties at the end of that term say, we love each other, let's do it again, let's do it for another year, let's do it another 5 years, I don't know. But there's also a beginning and an end where two parties can say, you know what, time's up, we're going to go our separate paths, because that's contract law. And I believe we were violating the fundamental basis of contract law under this bill.
Thank you, Madam Chair. I just want to try to, I understand and I appreciate what you're saying, Delegate Adams, about asking for legal clarification. I think in some cases, the request is your frustration with what the bill is and your disagreement with what the bill says. And so council may or may not be able to satisfy that frustration. But I think I just want to highlight a couple of things. First of all, Delegate Weigel, you asked about, is there a lawsuit if a county does it differently? I don't think that that's how local enabling legislation works. Like, my understanding of it, unless you understand it differently, is that when we pass, and we have a bunch of other things that we make enabling, including like local taxes and what have you, we pass it, we say, this is the structure you can operate within. These are things you can change. These are things you can't change. Like, here's the cap of what you can charge in taxes, right? But you don't have to charge that cap, right? Those kinds of things. And then local jurisdictions set it so that it works for them. And if they set it in a way that's inconsistent with state law, it just becomes unenforceable. So if a tenant tries to stay or a landlord tries to kick someone out and it's not consistent with state law, it just isn't enforceable by the district court at the local level when someone tries to take an action. So I think I don't see that there's anything in here, and council can correct me if I'm wrong, but that would lead to the Attorney General suing a local jurisdiction for taking it on in a way that's different from what the enabling legislation allows. I did want to clarify again, there's nothing here that, as I understand it, and again, I appreciate that there's disagreement with the policy, but there's nothing that changes the no right of redemption. If you follow through and end up with right of redemption and end up evicting a tenant because of that, nothing here supersedes that. This would just be, as I'm reading it, this would just be that if you don't go through no right of redemption and a tenant pays on day 11 and day 11 and day 11 and day 11, but hasn't gone through the court process with 3 judgments, then that couldn't be a reason. So this doesn't change any of the tools a landlord currently has, but it does change if it was day 11, day 11, day 11, day 11, then they couldn't use the end of the lease to get rid of someone. So that's my understanding of it. And again, if council sees that differently, I'm open to correction on that. And then the last thing that I wanted to just highlight is that there are several states that do have this, including Connecticut, DC, New Jersey, New Hampshire, Colorado, Washington State, Oregon, New York. It's an opt-out. St. Paul, Philadelphia. So, and they're not exactly the same, but similar laws. So this idea that it's unworkable, I understand disagreement, and I think it's reasonable to have policy disagreements, but I don't think it's unworkable because I think we can look around the country and see places where it has worked. Thank you, Madam Chair.
Thank you, Madam Chair. I know this is a difficult bill. We had to vote on this at local level as a Montgomery County bill for several years, and it was always controversial. So my first question is very simple. Whoever can answer that question, maybe the council, which is, this is the enabling legislation. Can I assume that means current Maryland law prohibits local counties from having their own good cause eviction bills or laws?
I don't think it's spoken to in the code about what a local jurisdiction can or can't do, but this would be the framework for a local jurisdiction to have good cause grounds for evicting a tenant.
Okay, so along that vein, can I ask how many counties have actually asked for this, besides Montgomery County, which we know because we had to vote on that bill?
I'm not sure about the counties that have asked for this, but yeah.
Like, they cannot do it themselves, that's why they asked the state to do it as an enabling legislation? We don't know.
Well, this bill would be providing the counties a framework to have good cause in their county, yeah.
So why don't the counties do it themselves? Because a lot of counties are very aggressive in regulating landlord-tenant relations. Maybe the vice chair can answer the question.
It's my understanding that the eviction law is set at the state level, and so if we want eviction procedures to be different county by county or to enable it county by county, that's within the state's jurisdiction to do that. And I think, I'm getting notes here, that Montgomery County, Prince George's, and Baltimore City have tried local laws, have tried to do it locally, or through the delegation. So those would be the ones who have expressed interest. That doesn't mean they'll do it once we pass this, but that's where
Okay.
there's been expressed
That's
interest.
helpful. Okay, so the largest the jurisdictions, okay. So do we have any data about the 7 or 8 states, 6 or 7 states maybe, that have this law on the books right now? How has that worked to prevent eviction, so to speak, or just, lease non-renewal? To me, this sounds more like a lease non-renewal than midterm eviction, because what we are really talking about is not eviction in the middle of the term, it's lease non-renewal, right? Has it actually prevented lease non-renewal in other states? And also to the point of Greater Bethesda's letter, which sort of also answers Delegate Queen's question, what their concern is, right? Which is, in a good cause system, the tenant can either ignore or disagree with the cause given, thereby requiring other neighbors to testify in court or sign affidavits against the disruptive tenant, right? So do we know how that has worked?
So regarding other tenants submitting affidavits against a tenant who perhaps is engaging in routine disorderly conduct, if they're trying to avail, the landlord was trying to avail themselves of that ground, I think that's maybe one possible scenario, but I don't know that that's either particularly likely or that there, of course, aren't many other ways for it to be established that a tenant's engaging in routine disorderly conduct, like through the landlord, the property manager, security cameras, police reports, et cetera.
Yeah, so, okay, well, my last question, which I really wish there could be some kind of answer, is I understand this is simply an enabling legislation. And as a renter, I used to be a renter, in my younger years. I can certainly appreciate the intent, which is if you are going to terminate the lease, you should at least give people a reason why you're terminating, right? Let's say if I have been a good tenant, I have been, a good neighbor, I can't think of any reason why all of a sudden you give me a notification, I have children, elderly, whatever, right? I want to stay here, and all of a sudden I'm being told to leave. I would appreciate given a reason, but that is not what this is, right? Because it's not enough to just give a reason. What if the tenant disagrees with the reason? That is what I'm not clear about. What if the tenant says, well, I disagree? Then what? I asked that question many times over the course of having to vote on that bill, right? And I never got a straight answer. I assume that you have to go to court, basically.
That's right.
That's correct. And I know people who are non-native English speakers who are small-time landlords who will be afraid of going through that legal process, which is a viable concern. All right. I don't think I will get that answer ever. Thank you.
That's the answer. I'll give you that.
Okay.
I mean, the process right now to get someone to vacate a property, whether it's because of tenant holding over at the end of a lease or because of an eviction process that's happening for other causes in the course of the lease, is to go to court. That's currently the process. And so if a tenant stays beyond the lease and the landlord wants to get rid of them, right now, they have to go to court, right? So like, let's say the tenant, I guess this isn't different, except that the court can either use or not use these reasons. So right now, let's say a tenant is like, I've been a good tenant, I should stay, my kids are in the school, my elderly parents are in the senior daycare center. I'm sorry, I totally just didn't get answered. Is that okay if I just, okay. If the landlord wants to remove them, they have to go to court now. The difference with this would be when they go to court, they'd have to say it's because of one of these three things. So it doesn't actually change the status quo, it just changes what gets counted once you get to court. Does that
To go
answer
to
your question?
court. Yes,
Yeah.
okay. Procedure, yes, thank you.
Okay, seeing no further questions, there was a motion favorable and a second on House Bill 774. No further discussion. Vice Chair.
Yes.
Delegate Turner? Oh, Jesus. No.
No.
Delegate Turner?
No.
Delegate Fennell? Delegate Pruski? Delegate Howard? Delegate Johnson? Delegate Boifo is excused. Delegate Bandari?
Yes.
Delegate Rogers?
Yes.
Delegate Chi?
No.
Delegate Arentz? Delegate Queen? I've never heard that one. No, I've never checked that. It threw me off. Delegate Ampry?
Yes.
Delegate Adams?
Thank you for the debate.
Delegate Pippy? Delegate Crosby's excused. Delegate Rose is excused. Delegate Wyville? Delegate Roberts? Chair votes yes. 2, 3, 4. Okay. House Bill 774 does not pass for lack of votes. All right. All right. No, did not pass. Motion failed. All right, that is the last bill on the docket. Thank you very much. Stay tuned for further voting sessions.